Hey, what's going on, everybody? So, I wanted to do a really quick video to discuss R. Kelly's bail situation and what it means for R. Kelly, or what I think it means. As you know, I'm not a lawyer. I don't have a degree in law. My name is not Steve Greenberg. So, basically, this is just my own opinion, right? So, he has a federal case in Chicago and in New York. Both of those, he's been denied bail, right? So let's talk about what that could possibly mean for R. Kelly. So, first off, let's just have a look at the statute really quickly. And when we look at the statute in question that basically governs bail generally, it's called 18 USC 3142, and it's called release or detention of a defendant pending trial, right? So basically, you're looking at four possible outcomes when it comes to asking a judge to let you go, right? The first outcome is that basically, I'm just going to read the statute, right? And then we'll talk about what I think it means. And generally, upon the appearance before a judicial officer, a judge, a person charged with an offense, the judicial officer shall issue an order that pending that trial, the person be one, released on personal recognizance or upon execution of an unsecured appearance bond under subsection B of this section, right? Two, release on a condition or combination of conditions under subsection C of this section, right? And then three, temporarily detained to permit revocation of conditional release, deportation, exclusion under subsection D. And then four, detained under subsection E of the section. So just to do a quick recap, there's four possible outcomes. I don't see you getting anything outside of these four possible outcomes when you're asking for bail. You may get a combination. I don't even know if that's possible, but generally you're looking at four possible outcomes. And then number one, the first possible outcome is that they say, "Okay, buddy, we're going to let you go. We trust you, and there's little to no risk of letting you go. So we're just going to go ahead and let you go. This is your next trial date, and we hope to see you. If we don't see you, we'll put a warrant out on your for your arrest, right? So that's the condition number one. And uh, option two, or possibility two. I'm sorry. Let's just say these are possibilities. So the first possibility is they let you go. The second possibility is that they'll say, okay, we're going to release you, but we don't want to take the risk of releasing you and have you not show up for and have you just go out there and just do something totally crazy. So this is what we're going to do. You give us X amount of dollars and you follow these conditions, like, I don't know, put a electronic monitoring bracelet on your feet, or report to a parole officer, or anything that the court can think of to basically monitor you, or to put you in a situation where they can feel comfortable that if they let you go, you're going to, number one, show up for trial, and then number two, you're not going to go out there and do something crazy, right? Because I think one of the things with when you're dealing with people that are in these situations is that they sometimes become desperados. And, a desperado basically is somebody who doesn't believe they have a future, they're desperate, they'll do anything for quick pleasure, or for possible freedom. So they're going to ask for some type of condition to make sure you don't just go out there and just start acting buck wild, right? So that's the second possibility. They release you and they say, well, the second possibility is they say, we're going to let you go until the trial, but here are the conditions, right? And then number three, the third possibility is they say, you know what? We're going to temporarily hold you, right? We're going to temporarily detain you to make sure we have all our ducks in a row, and to, see what the best option is at this point. We don't know what the best option is. We don't know that letting you go is the best option. So we're just going to temporarily detain you. We're going to do some homework, or we're going to have your lawyers and the prosecutor do some homework, and then we're going to come back and make a decision on whether or not we're going to release you or we're going to keep you. And then four, The fourth possibility is that they just keep you locked up until your trial date. And we'll get into why they would do something like that in 1 second. But, generally, these are the four possibilities or the four possible outcomes you can end up when you ask the judge to let you go on bail. So let's just go ahead and skip down to E if I can find it. Okay, so basically, subsection E, if after a hearing pursuant to the provision of subsection F of the subsection, the judicial officer finds that no condition or combination of conditions will reasonably assure the appearance of the person as required and the safety of other persons and the community, such judicial officer shall order the detention of the person before trial. Basically, they're saying we don't feel safe. So because we don't feel safe, we're just going to lock you up. We don't feel safe and we don't believe you're going to show up. So we're just going to lock you up. Right. So I don't think there's any reason to continue reading subsection E. Let's skip around a little bit. And subsection F, which was mentioned in subsection E. Let's read some of that. Detention hearing. The judicial officer shall hold a hearing to determine whether any condition or combination of conditions set forth in subsection C of the section will reasonably assure the appearance of such person as required and the safety of other persons and the community. So subsection F is basically going to be used to figure out if we can let you out, and if we can, what the conditions or what the requirements are going to be, or what you're going to have to do to basically prove that you're worthy to be let out, right? So F1, it goes upon motion of the attorney for the government in a case that involves one, a crime of violence, a crime of section 1591. I don't know what that is. I'm not going to look it up. Or an offense listed in sections 2332BG5B. Feels like I'm playing bingo here. For which maximum term of imprisonment of 10 years or more is prescribed. And then F1B, an offense for which the maximum sentence is life imprisonment or death, right? Or subsection F1C, an officer for which a maximum term, I'm sorry, an offense for which maximum term of imprisonment of 10 years or more is prescribed in the Controlled Substance Act. Okay, so basically drugs. I'm not going to read the rest of it. And then subsection F1D, any felony, if such person has been convicted of two or more offenses described in subsections or subparagraphs A through C of this paragraph, or two or more state or local offenses that would have been offenses described in subparagraphs A through C of this paragraph, if circumstances giving rise to federal jurisdiction had existed, or a combination of such offenses. Or E, F1E, any felony that is not otherwise a crime of violence. I'm sorry, any felony that is not otherwise a crime of violence that involves a minor victim or that involves possession or use of firearm or destructive device, as those terms defined in section 921, or any other dangerous weapon, or involves a failure to register under section 2250 of Title 18 United States Code. Or F2, upon motion of the attorney, upon motion of the attorney for the government or upon judicial officer own motion in the case that involves A, a serious risk that a person will flee, or B, a serious risk that such a person will construct or attempt to obstruct justice, or threaten, injure, or intimidate, or attempt to threaten, injure, intimidate a prospective witness or juror. Right. So, you know what? I'm not sure what the judge was thinking when he basically denied R. Kelly bail, or shall I say judges for that matter. But to me, it looks like generally they are basically, I mean, according to the statute, you have to consider the risk that they're going to show up. And then you also have to consider the safety of any other person in the community. And then you have to consider the risks that the person will obstruct or attempt to obstruct justice, or threaten, injure, or intimidate, or attempt to threaten, injure, or intimidate a prospective witness or juror. Now, I'm guessing because some of the charges in Chicago involves R. Kelly basically cheating the first trial, right? Those are some of the charges. They're alleging that R. Kelly cheated in his first trial, and they're alleging he accomplished that by actually witness tampering. I'm going to bet that that was one of the things they thought about. That, hey, he may intimidate the witness, and I think Greenberg even commented on the fact that, not the fact, Greenberg commented on that there was little to no risk of him assaulting anyone, and there was little to no risk of him being a danger to the community. So the judge must have, right? In my mind, I'm thinking he's probably considering subsection F to A and B. This guy might run, or he might try to rig the trial again, right? Allegedly, right? That's probably what the judge was thinking about. So, that's basically the gist of, and I think also, I think you can't be released. I may have read too fast, but I think you can't be released if there's a minor child involved. I'm just going to cheat really fast. We'll just do a quick word search. Yeah, so FE. I'm sorry. Yeah, so I actually read it. I guess I didn't think to stop. But E, any felony that is not otherwise a crime of violence that involves a minor victim. So it looks like there could have possibly been a combination of factors that both judges, the judge in Chicago and New York, I don't know which hearing would be tougher, because Chicago is a tough city, New York is a tough city. So I would imagine the judges probably have seen all range of crimes versus being in maybe some sleepy town where a heinous crime doesn't happen that often. I would imagine the judges are a little bit tougher. I don't know. I digress. That's just me, going on a tangent. Let me know what you think. Do you think New York and Chicago are tougher, therefore the judges are tougher in these cities, as opposed to a place like, I don't know, Wyoming, right, or Vermont, right? Those little sleepy towns or sleepy cities. So let me know. Let me know what you think. Do you think Chicago? I would say Chicago, New York, LA. Those are probably tougher cities. So you probably get a full range of crimes, and judges probably see them all. That's just my guess. Anyway, let me stop digressing. So I'm thinking that R. Kelly basically was, I'm sorry, I'm thinking the judges basically decided on not giving him bail because of the victims being minors, or some of the alleged victims were minors, and that there's a risk that he's going to flee, and there's a risk that he could obstruct justice, right? So that's the legal part of it. Let me just talk about what I think. I think the judge probably was well within his right, or probably did the right thing by not granting him bail. I'm not, so don't beat me up, don't chew my head off. I'm not saying R. Kelly is guilty. I'm just saying that, this is the statute, and the statute governs the conditions on which you can basically grant bail. And basically it says that, so long as the child, I mean, so long as there's not a minor child, so that alone would basically, keep R. Kelly, locked up. That one clause alone. So based on subsection E and subsection 1E and subsection 2B, he can't be released, right? Because there's an allegation of witness tampering. So the judge can't release him. So let's just throw all that aside. I think that the denial of bail is a victory for the prosecutors. And here's why. Because basically, I've never been locked up for an extended period of time. I have been in jail, and I've been locked up for probably, I would say, less than a week. And I'm telling you, I pretty much just broke on the first day, right? Because I have a life, I have things that I want to do, places I want to go, people I want to see, and me being locked up in jail just doesn't really, it's just not happening. There's nowhere in the world that I'm going to be locked up in jail on some BS. So if I can't be locked up for a day, I can imagine what it's like for people who are locked up for years before they actually get to trial, right? So I think it's a victory for the prosecutors because the prosecutors now have you bent over, right? So they probably are now going to wait. They're going to continue to let the charges mount up, and then they're probably going to wait. And then they're going to probably approach R. Kelly or R. Kelly's lawyer with some type of plea deal. And there's another video that someone sent me, and I think that Irv Gotti was offered a plea deal. I don't know if he was locked up at the time, but Irv Gotti was actually locked up, and they offered him a plea deal, and he basically threw it back at him. He took the plea deal and threw it in the garbage. I think in R. Kelly's situation, considering the circumstances, he may not be able to do that, right? Because he's basically fighting a losing battle. The finances, I believe, his finances are depleting, right? The money that he's getting from the residuals are a lot of that money is spoken for already, and he's constantly being taken back to court to be sued. I don't know if he's broke. I don't know, but basically they're attacking his finances at the same time that they're trying to prosecute him criminally. So the finances are depleting. He's in jail, and it's going to basically crush his spirit. And then not only is he in jail, but they've limited what he can do in jail. Like he's in solitary confinement. So I think I actually read another article where he can only make like one phone call every so often, right? A 15-minute phone call every so often. So basically, they have this guy in 100% total isolation. They're trying to break him. They're absolutely going to try to break him. And I think R. Kelly is just a man like all of us. And I think that most men crumble. I'm not gonna lie to you, I crumble. Like I couldn't even stay in jail for a day, before I, started to break down in tears. So I can imagine what it's been like for R. Kelly for the time that he's been in jail. Ultimately, I believe the denial of bail was probably the right decision for a judge. I mean, you tell me if you were a judge and basically you're reading the statute, and the statute basically asks you if the victim was a minor child, right? And then the statute asks you if there was a risk of obstruction of justice or witness tampering with you under the conditions based on what you know about the case, whether you love R. Kelly or not. Under these conditions, would you grant R. Kelly bail? Right? I think ultimately it's a victory for the government because now they can do whatever they want to do to him. Right? They can do just about. They can. You know what? I've never been locked up in federal prison. I don't know what powers the government actually has over prisoners, but I would imagine they can move him from prison to prison. They already have him in solitary confinement. They can do things to try to break and crush his spirit. So that's essentially what I'm saying. So that's it for this video. Let me know what you think. Do you think the denial of bail is a victory for the federal prosecutors? Do you think it's going to be tougher for R. Kelly now because the federal prosecutors can actually, or the federal government can now do whatever they want to do, or just about whatever they want to do to R. Kelly to try to break him? Let me know what you think. Leave your questions and comments below.